All right, Mr. Schmidt, you finally ready?
Ready to, finally, yes, sir.
All right, who do you want to call first?
Mr. Cronin, come on down. Joseph Cronin.
All right, this is cause number. Let's see, do I have Cronin? Is he a write-in or let me see? See on the back page?
Back.
Joseph Paul Cronin, CR 22322. Is this a plea, Mr. Schmidt?
It is, sir.
All right, Mr. Cronin, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thanks. Lower your hand, make sure you speak up loudly and clearly so I can hear you. All right, Mr. Cronin, you did appear before this court previously on, now let me see. All right, hang on just a second. I don't have a copy of the state's motion. I got everything but that. Give me a second. Let me pull that up just so I can read from it. All right. Sorry for the delay. All right. So, Mr. Cronin, you appeared before the court on June 1st, 2023. You pled guilty to the second-degree felony offense of arson. The court heard the evidence and found that there was a plea agreement between you and the state in which the court approved. The court assessed your punishment at 6 years confinement in prison with a $750 fine, and the court then suspended that sentence and placed you on community supervision for 4 years. It was during that period of community supervision that the state filed a motion to revoke, alleging what appears to be 8 separate counts of violations. Have you had enough time to review that with your attorney, Mr. Schmidt? Mr. Cronin, have you had enough time to review that with Mr. Schmidt?
Yes, sir.
All right, you got to speak up or I can't hear you. And do you feel like you've had enough time to talk with him about your case, that you've had all of your legal questions answered and you don't have anything further before we go forward?
Yes, sir.
All right, Mr. Schmidt, do you believe Mr. Cronin to be competent? And if so, is he pleading true to all counts?
Yes, sir. I believe he's competent. We intend to plead true to all counts and wait for the reading of the state's motion.
All right. Mr. Cronin, and do you have a copy of the motion there for him to review with you, Mr. Schmidt?
I do not. It's not included in the paperwork. We reviewed that yesterday.
Just in case you need it here.
Yes, sir.
And if you can't see that, let me know if I need to make it larger or smaller. All right, Mr. Cronin, then at this time, I'm going to ask you, how do you plead to counts 1, 2, 3, 4, 5, 6, 7, and 8? Are those counts true or not true, sir?
Yes, become true.
And are you pleading true to each one of those because what the state is alleging in this motion is in fact true? Is that correct?
Yes, sir. Yes, sir.
Okay. And has anybody threatened you, forced you, or pressured you to plead true to any of these counts?
No.
All right, court does accept the defendant's plea of true to each count as alleged. Mr. Schmidt, any objection to the defendant's waiver of rights and admissions being admitted into evidence?
No objection.
All right, that is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
All right, and so the court, based on the defendant's plea of true to each of the counts alleged, the court finds each count to be true. And on that finding, the court concludes that the defendant has violated the terms and conditions of his community supervision. Court hereby follows the plea agreement that has been reached with the state today. The court revokes the community supervision of Joseph Paul Cronin, assesses his sentence at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his fines, court costs, and reimbursement fees. Further, the court will award Mr. Cronin 296 days of credit time for the time that he has already spent in jail on this case. Mr. Cronin, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. All right, who's next, Mr. Schmidt?
Is it Langley?
All right, Ms. Langley. Ma'am, if you will raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You may lower your hand. Your name is Lisa Ann Langley, is that correct?
Close enough.
Is it Liza?
Lisa.
Lisa?
Mhm.
Man, I didn't think there was a third pronunciation, but of course I picked the first two.
Yes,
Lisa, okay.
sir.
And it appears that you were before the court previously on May 11th of 2021.
Yes, sir.
You pled guilty to possession of a controlled substance between 4 grams and 400 grams in penalty group 2, that it was a second-degree felony. The court found that there was enough evidence to convict you on that date. However, the court did follow a plea agreement between you and the state wherein the court deferred a finding of guilt and placed you on community supervision for 4 years, assessed a $1,500 fine. And during that period of probation, the state filed its motion to adjudicate and revoke. That was filed February 29th of 2024. And in that motion, they alleged 8 separate counts of violations. Have you had enough time to go over this motion with your attorney, Mr. Schmidt?
Yes, sir.
Do you understand everything that you have read, signed, and agreed to in your plea agreement?
Yes, sir.
And are you pleased with Mr. Schmidt and the work he's done for you?
Absolutely.
Mr. Schmidt, do you believe Ms. Langley to be competent to enter into this agreement? And if so, is she pleading true to all 8 counts alleged?
Yes, sir. She is competent and she is intending to be true. We do have a copy of the state's motion before us in our packet.
Thank you. So, Ms. Langley, I see here that the plea agreement is upon your plea of true, the state's recommending that you be adjudicated of the offense today. That means that the court would convict you for that possession of controlled substance, that your community supervision would then be, or that punishment would then be assessed at 5 years confinement in TDC in prison, but your sentence being suspended and you being placed on 5 years community supervision. So you understand that you would be convicted of the crime today and your probation would go from a deferred probation to what we call a straight probation.
Yes, sir.
Before I take you off deferred probation and put you on straight probation, can you tell me in your own words why you're going to be successful this time when you weren't last time?
Because I have a full support system now and a very well-able support system. And I have nothing that's going to hold me back from succeeding all the way. I was almost finished as it was with probation the first time, and I had not messed up, not once. So I'm just going to take it for everything it's got and continue to succeed.
All right, I appreciate that. And you understand the thing about a support system is the support system is the resources and the people that are around someone or something. You understand that you are that someone, right? You
Yeah.
understand that the support system doesn't work unless the person in the middle is working.
Absolutely,
And I'm not talking about a job. You understand what I'm saying?
sir.
Talking about being drug-free and being sober and being productive and being clean
Yes,
and
sir.
doing the right things and having a job and taking care of responsibilities and being a productive citizen. You understand? Support system doesn't work if you don't work.
I absolutely understand.
Okay. So you're telling me that if I put you back on community supervision, that we're not going to have this kind of hearing again?
Absolutely not. Gonna have this situation happen again.
All right. All right. So Miss Langley, at this time, how do you plead to all 8 counts? Are those counts true or not true?
Sure.
And has anybody threatened, forced, or pressured you to plead true to any of those?
No, sir.
All right. The court will find that the defendant's pleas of true are voluntary. The court will accept the defendant's pleas of true. Mr. Schmidt, any objection to her admission and waiver of rights and waiver of whatever this document is called here? Defendant's waiver of rights and plea of true. Any objection to that being admitted in evidence?
No, sir, no objection.
That is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense, Mr. Schmidt?
No, sir.
All right, then based on the evidence before the court finds that Lisa Ann Langley has violated the terms and conditions of her community supervision. The court will follow the plea agreement this date. The court convicts her of possession of a controlled substance in penalty group 2 greater than 4 grams, less than 400 grams. The court assesses her punishment at 5 years confinement in the Texas Department of Criminal Justice. The court will suspend that sentence today and place her on 5 years community supervision, order her to pay the balance of her previous financial obligations, which includes a $1,500 fine, $180 restitution, and $1,070 in reimbursement fees. Ms. Langley, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted, and then you can talk with the probation officers.
Thank you, Your Honor.
You're welcome.
I went.
She's talking.
Ms. Abraham, do you want me to bring Mr. Schmidt in, Brian Schmidt?
Sure.
All right, let me see. And is his inmate?
She's in Henderson County.
Okay, I don't see Henderson County.
Oh, okay.
In the waiting room.
Well, they may be together. He said he might go to Henderson County.
Okay, well, let's try that and see.
Okay.
Good afternoon, Mr. Schmidt.
Afternoon, Judge.
Well, we were just discussing and wondering if you were with your client at the jail, and it doesn't appear that you are. So I don't have her. Well, I don't have Henderson County logged in at this time.
So I know there was some confusion. And so I spoke with the major there yesterday, and we forwarded him the link. So it was my understanding that, and I copied Ms. Abraham, my understanding that they would have her on. She knows what's going to happen today, Judge, based upon where she's at. So, and so I don't mind proceeding without her and kind of explaining to the court what's going on. I would have been there if I thought she wasn't going to be on.
Before we go without her presence, that it just makes me a little nervous. But let me see if I can have Ms. Abraham reach out to the Henderson County Jail real quick and see if we can get her on. And
Sure.
And Ms. Abraham, was that scheduled for 1:30 or was it 2 or a special time?
1:30.
1:30. Do you have the Henderson County Justice Center info with you, Ms. Abraham?
No, but I can look it up.
Judge, I can make a phone call if you like.
Yeah, if you don't mind, Mr. Schmidt, and I'm just going to leave you in this session. If you want to just turn off your mic and camera, and then once she gets into the waiting room, I'll bring her in, and then you can turn it back on.
Thank you, Judge.
All right, thanks, sir.
Mr. Lowe is ready now on Mr. Gerard.
All right. All right. Good afternoon, Mr. Lowe. Good afternoon, Mr. Gerard. How are you, sir?
Good afternoon. How are you doing, sir?
Hey, I'm doing fine. Thank you for asking. You're looking good and sounding good. Mr.
Thank
Lowe,
you.
are you ready for your status competency on Mr. Gerard's CR 2267?
Yes, sir.
Go ahead.
So we received a report from Vernon Hospital and they recommend that he be found competent. And I've agreed with the state that they can offer the report without objection. The court can find him. The competency is restored. And so where we are, Your Honor, is we have filed a notice of insanity plea. So we're still compiling records. I've got a psychiatrist the court authorized. I think we're probably we can reset this in a couple of months to see where we are on that plea, Your Honor. I've got a lot of records I've got to get to the doctor, and she has to do some other work. So a couple of months would be good.
All right. So are you thinking maybe late October or early November? What are you thinking?
Late October will be fine, Your Honor.
Okay. I've got, and what would we be setting it for? Just a status of her report, or are we setting this for some type of evidentiary hearing?
It'd be, hopefully she'll have a report by then. So I need to put her on where we've got a deadline. So it'll be just a status on her finding as to the plea of insanity.
Okay. All right. How about we can do October 29th?
All right. Be
All right.
fine.
All right. So we'll set Mr. Gerard for, we'll call this status on insanity report, correct?
Yes, sir, Your Honor.
All right. We'll set that for October 29th. Mr. Gerard, I do want to ask you about, is the jail still getting you your medications, and is all that
Yes,
going
sir.
okay?
Yes, sir. I had an interview with Andrew Center today. They sent 7 days worth of meds, and then after that, Andrew Center is going to take over, and we're going to proceed with Andrew Center
Okay.
from Vernon.
Okay. Ms. Tabraham, I do want to note and ask you to follow up with the Andrew Center and make sure that we have Mr. Gerard's medications lined out so that the jail's not having any issues getting those, so that Mr. Lowe's not having to chase down that information, and that Mr. Gerard's not missing any of his scheduled medications. So if you'll help me remember that, and if you'll follow up with the Andrew Center to make sure that Mr. Gerard is getting what he needs.
Yes, sir, we
Thank you,
will.
Your Honor. Thank you.
All right. Thank you, gentlemen. Okay. And Mr. Gerard, if you have any issues, make sure you reach out to Mr. Lowe. And
Yes,
if there's any issues with medications or something like that, the jail staff is there to help. And
Yes, sir.
you can always contact the court as well on those issues. Anything else about your case? Mr. Lowe's your man.
Okay, thank you.
And,
All right.
and Your Honor, just for purpose of the record, state would offer that report for the court to consider.
Okay. All right. So the court will admit that without objection for consideration.
Thank you, Your Honor.
Thank you.
All right. Thank you, Mr. Lowe. Thank you, Mr. Gerard.
Thank you.
You're welcome.
I don't know.
Mr. Brian Schmidt, did you get any updates from the Henderson County Jail?
I did. I spoke with Major Fought. They're getting her connected very shortly. I'm not sure where the mix-up was, but she should be on here very shortly. So
Okay. I'll be watching for her, and I'll let you know as soon as I see them.
yes, sir.
Thanks for doing that. I appreciate it.
No problem.
Okay, Your Honor, Mr. Green is ready on Hunter Huggins.
All right, Mr. Huggins, come on up. Good afternoon, Mr. Green.
Good afternoon, Your Honor. How are you?
Oh, I'm doing fine, doing fine. This is cause number CR 20-124, State versus Hunter James Huggins. Is Mr. Huggins a plea today?
Judge, it is an agreement to dismiss the motion to revoke and to amend his conditions of probation for him to attend relapse safety.
Okay. And probation, the probation department, are they supportive? Ms. Burns, are you there?
Yes, sir.
And are you supportive?
Yes, sir.
All right, thank you for that. All right, Mr. Huggins, sir, if you will raise your right hand, I'm going to ask you a few questions. First of all, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. All right, Mr. Huggins, I heard the agreement from Mr. Green that the state's willing to withdraw their motion to adjudicate. And part of that agreement is that you will amend your your conditions of community supervision for placement in relapse safety rehab. Is that your agreement and what you're asking the court to approve today?
Yes, sir.
And has anybody threatened, forced, or pressured you to make that agreement?
Not at all.
Are you pleased with Mr. Green and the work that he's done for you?
Absolutely.
And you understand everything that you've read and signed as to your amendment of conditions?
Yes, sir.
Okay, all right, then the court will grant the state's motion to withdraw, the motion to adjudicate. Court amends the conditions of community supervision for Mr. Huggins to include, to continue him on community supervision, and also include a condition that he attend the relapse safety program. Court is signing the order this day. All right, anything further, Mr. Green?
No, Your Honor.
All right, thank you, sir.
You bet, may I be excused?
Yes, sir. Good to see you. Have a good day. Mr. Manning, who are you ready on, sir?
Judge ready on Mr. Graves, Stephen Graves.
Stephen Ford Graves, CR 2453 and CR 24135. I believe it were set for docket call in the former, pretrial in the latter.
Yes, Judge, we have no contested pretrial. At this time, we request that both these matters be set for docket call. We did receive an offer on Mr. Graves this week. I've conveyed that to Mr. Graves. This will resolve both filed cases and the unfiled case that is currently under investigation. If I may have some time to speak to him about the ins and outs of that, I believe we may be able to reach some sort of agreement on this case.
Okay, how long do you want me to set this for?
Judge, if we can just set it for middle of next month.
We can come back on the 26th. It's evidentiary day, but I don't mind putting him on there.
Judge, that'll be all right.
September 26th. All right.
Yes, Judge.
And so we'll set for docket call in each.
Yes, Judge.
All right. Court sets each case for docket call September 26th at 1:30.
Thank you, Judge. Next, ready on Mr. Jackson.
Jaquavion Antron Jackson, CR 21361. Motion to revoke. Go ahead, Mr. Manning.
Yes, Judge, I'm in the middle of attempting to verify some information from SafeP regarding my client's unsuccessful discharge from their program. I request he be set on September 26th for a final contested on that date.
Any objection from the state?
No objection, Your Honor. I'm familiar with the information that Mr. Manning's trying to gather and very well could determine the outcome of the motion.
Okay, very well. Court sets Mr. Jackson for a final hearing on September 26th at 1:30.
Next, Judge, we're ready to do arraignment on Mr. Bobby Shaw. If you could pull up the indictment, that would assist us in that process.
All right, so you're needing CR 24175, is that correct?
That's correct, Judge.
All right, give me just 1 second. Is that viewable, Mr. Manning?
It is, Judge. Okay, so this is Judge, his name is spelled correctly. He understands the charge as well as the range of punishment. At this time, he pleads not guilty and requests a pretrial on this matter.
All right, the court finds that Mr. Shaw has waived the formal requirements of arraignment. The court enters this plea of not guilty into the record, and the court sets this matter for pretrial hearing. Do you want that October 3rd date, Mr. Manning?
Yes, Judge.
Sets Mr. Shaw for pretrial October 3rd at 1:30. You're good, Mr. Shaw.
Thank you.
You're welcome.
Judge, next, Mr. Tatum.
Is he in the courtroom today?
He is, Judge.
All right, this is State of Texas versus James Terry Tatum, cause numbers CR 24-151 and 152. Believe that we're set for arraignment. Do you need the indictments, Mr. Manning?
Yes, Judge.
All right, give me just 1 second.
He's gonna pull up the paperwork so you can see it on the computer. He's gonna pull up the paperwork so you can see it on the computer. Okay, Mr. Tatum, is your name spelled correctly up here?
Yeah.
Okay. And you understand that the state of Texas, they're charging you with a violation of the health and safety code for possession of controlled substance, 1 to 4 grams, namely methamphetamines.
I didn't have no dope.
Hold on. And that's a 3rd-degree felony. Now, we're gonna plead not guilty at this point in time, so we can get the discovery and we can review that. You understand that?
Yeah, I plead guilty and get some probation or something, so I don't.
Okay, we'll negotiate that. But right now, we're pleading not guilty, so we can get all the discovery and go over that together. You understand?
I'd rather plead guilty to it, so I'd rather just go and get this over with if you could, please, sir.
Your Honor, at this time, my client's name is spelled correctly. He understands the charge against him. Oh,
Homeless, could you please help me out here, sir? I'll go ahead and plead guilty to it, sir.
Judge, at this time, we request he be reset on the pretrial docket.
All right, let me show you the other. See, that was 152. I need to show you the other indictment, correct?
151, that's correct.
Could you help me out? I'm homeless. I ain't got nowhere to go.
Just
Okay.
Mr. Tatum, let Mr. Manning do the talking for you, okay? He's your lawyer. I want you to listen and let him advise you on what your legal rights are and how best to proceed in the case, okay? So I want you to trust Mr. Manning and talk to him in private, okay?
Sir, what?
I want you to trust Mr. Manning as your lawyer. Talk to him about your case. Don't talk to me about your case. Don't talk to anybody else there in the courtroom about your case. Talk to Mr.
I'll
Manning.
go ahead and plead guilty to it, sir.
All right, Mr. Manning, I'm going to, I understand that Mr. Tatum has been found incompetent previously in this court, in other courts in Van Zandt County. I understand that at our hearing last week, I believe, or 2 weeks ago, the most recent time, Mr. Tatum was unable to appear in court due to possible mental health issues. The court is going to enter Mr. Tatum's pleas of not guilty into the record, just for purposes of arraignment. The court understands that he may not understand at this time what he's charged with, but I'm going to enter his plea of not guilty into the record. I anticipate, Mr. Manning, that you may be filing some type of motion to determine competency from Mr. Tatum. I'm going to
Yes,
go ahead.
Judge, and I apologize. I thought I had filed a motion and order on him, but when I went back and looked at my file, that was in fact from a previous representation of Mr. Tatum. So I will get an updated order requesting he be evaluated before tomorrow.
Understand. And just so you're aware, Mr. Hartwell advised the court this morning that you and he had those conversations and what the issue was as to why you didn't already have it filed and what your understanding was. So court does understand that. And so I'm going to reset this until for October 3rd. And we'll set it for status on competency report.
Thank you, Judge.
October 3rd in each case. Do you need some time or do you have?
Judge, we're getting paperwork printed out for our last two, and then we'll be ready to go.
All right, I'm going to go ahead and Mr. Brian Schmidt, if you want to log back in, then I believe the Henderson County Jail is here. I'm going to try to bring them in. Give them just a moment.
I'll still be on.
Miss Wiggins, can you see and hear me okay?
Yes, ma'am. Yes, sir. Okay. Yes, sir. I now see you. Yes, sir.
Okay, excellent. Yeah, I knew y'all were getting logged in. Mr.
Yes, sir.
Schmidt is here and Mr. Schmidt, can you turn your camera on? See,
Oh.
Okay. I see him.
you see him? Okay, excellent.
Yes, sir.
All right, this is cause number CR 15123. State of Texas versus Katie Lynn Wiggins on the state's motion to revoke. Go ahead, Mr. Schmidt. I believe you had an announcement for the court.
I do, Judge. Discussed this case with Mr. Hartwell at length. If you recall, we were actually set for a contested hearing back in June, I believe, and Ms. Wiggins was arrested on a new allegation out of Henderson County. She's recently been indicted on a first-degree felony charge and what appears to be a lesser-included state jail charge. Mr. James Mills has been recently appointed. Robert Perkins was appointed, but there was a conflict because he was appointed on the co-defendant. So Mr. Mills has been recently appointed. She's set for arraignment September 18th at 9 o'clock in the 392nd District Court. I expect they will plead not guilty and the pretrial will be set about 60 days out. I think Mr. Hartwell and I are of the opinion, if the court is accepting of it, to kind of see what happens with Henderson County. She's in on $125,000 worth of bonds there. She's still experiencing the same medical issues that she was in the Van Zandt County Jail. But if for some reason she had a bond reduction there, you do have $100,000 hold on her. So we were thinking maybe set this case out about 60 to 90 days to allow Mr. Mills and the state to talk about the new allegations.
Any objection from the state?
Oh, Your Honor, I think what happens in Henderson may very well influence what kind of an offer we would make in this case here.
All right, then what I'll do is I'll set it for the evidentiary docket on 90 days would be about November. So I'm going to say November 26th. That'll be the week of Thanksgiving. Make sure that there's no conflict with your schedules. That would be the Tuesday before Thanksgiving.
That's fine with me, Your Honor.
Okay. All right. Court sets Ms. Wiggins in November 26th at 1:30.
Very good.
All right. If there's nothing further, then we're adjourned. Ms. Wiggins, if you will, please, for me, tell the jail staff I appreciate them getting you in here and getting you hooked up on Zoom so we could do this hearing.
Yes, sir. Thank you.
You're
Thank you
welcome.
very much.
You're welcome. Have a good day.
You too.
Judge, that is all I have. My excuse.
Yes. Thank you, Mr. Schmidt. Good to see you.
All right. Thank you all.
All right. Let's get jail back on here. All right, Mr. Abraham, if you could turn the jail camera back on. Excellent. Mr. Manning, are we ready?
Yes, Judge.
All right. Who would you like first?
We can do Mr. Collard, Anthony Collard.
Anthony Dale Collard, CR 21-110. Motion to revoke. Go ahead.
Judge, we reached an agreement that the state's going to withdraw their motion to revoke and continue him on community supervision. The terms of that are they going to withdraw and extend for a period of 2 years. They're going to use up 147 days in the county jail as a condition of probation. And they're going to add the new attorney fees of $500. I've spoken to my client. He has signed that amendment to his condition of probation. And we have all the paperwork in order on our side.
All right. And Ms. Burns, probation department is supportive of Mr. Collard remaining on the supervision caseload?
Yes, sir.
All right, Mr. Collard, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Do you understand, Mr. Collard, that this agreement that Mr. Manning has informed the court of, you understand that that would extend your probationary period an additional 2 years? You understand that?
Yes.
Means you're going to have to report, you're going to have to pay, you're going to have additional obligations during that time. Is that correct?
Yes.
And you understand that if you get another motion to revoke, and if you're taken to a hearing and your community supervision is revoked and a sentence is assessed, which it looks like you're on a 3rd degree, 2 to 10, if a sentence is assessed, you understand that you would not receive any credit time for the 147 days that you've spent in jail that they are taking as part of this agreement. You understand that?
Sure.
And you understand that you're also going to be ordered to pay an additional $500 for the filing of this motion and the appointing of Mr. Manning as your attorney.
Yes, sir.
Has anybody threatened, forced, or pressured you, Mr. Collard, to make this agreement here today?
No.
Are you pleased with Mr. Manning and the work that he's done for you?
Yes.
And Mr. Collard, just in your own words, tell me why I should approve this. Why should I put you back on probation if you didn't do what you said and I told you to do last time?
Well, for a year, I was without a vehicle. For 1 year, and I didn't have a ride. And now I have a good vehicle and a good job now. Those 2 things I didn't have prior, not having both now, so that would change my whole perspective.
And you understand that while I played baseball growing up and I'm a big baseball fan now, I don't believe in 3 strikes when it comes to criminal justice. I'm not one of those people that thinks you should get 3 strikes or chance after chance after chance. Do you understand that?
Yes, sir.
Next time you come back in on a motion, the state may even recommend that we withdraw the motion. I may not agree with that. I may not allow it next time. You understand that?
Yes, sir.
So when someone says they're going to do something, I expect them to do it. If I told you I was going to do something, you would expect me to do it, right?
Yes, sir.
So it's a two-way street. I expect you to do it. All right. So no more excuses, no more motions. You understand? You understand?
Yes, sir.
All right. Anything further, Mr. Manning?
Nothing from the defense, Judge.
All right, then the court will approve the state's motion to withdraw. The court will continue Mr. Collard on community supervision. The court extends his supervision period for an additional 2 years. The court orders that he serve 147 days in the county jail as a condition of probation. They will receive credit for any of that time already served, as reflected in the motion and order. And the court also amends to include an additional attorney fee amount of $500. All right, Mr. Collar, step over and sign your amendment to your conditions of community supervision, and they'll work on processing you out.
Okay, thank you.
Anything else? Auditor?
Yeah. Verify something with it. Oh, that's- Let me just verify.
Judge, if we may have just a minute.
Sure, no problem.
Judge, we're ready on a plea for Miss Joyce Wood.
All right, Ms. Wood, if you will raise your right hand, I'm going to place you under oath. Ms. Wood, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Joyce Marie Wood, is that correct?
Yes, sir.
And Ms. Wood, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition,
Depression.
depression,
PTSD.
PTSD? Are you currently on medication for that?
Yes, sir.
Do you feel like you have a rational understanding of what's going on in court here today, or do you feel like your PTSD is preventing you from having clear thought?
No, sir. I have a rational opinion.
All right. In this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and that you've had all of your legal questions answered and that you understand everything that you've read and signed that's part of your plea agreement?
Yes, sir.
Do you have any questions about anything before we go further?
No, sir.
Mr. Manning, do you believe Ms. Wood to be competent?
I do, Judge.
And you have explained to her her rights as they pertain to this case?
I have explained her rights. I believe she's intentionally, knowingly, and voluntarily waiving those rights.
All right, Ms. Wood, you are charged by indictment with a first-degree felony offense of aggravated sexual assault of a child. That does carry a range of punishment of not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice, and a possible fine not to exceed $10,000. I see that the plea agreement in your case, upon your plea of guilty, the state's recommending to the court that your punishment be assessed at 30 years confinement in prison and a $2,000 fine. In addition, court costs of $290 in reimbursement fees of $20. Is that your understanding of the plea agreement, Ms. Wood? And also, Ms. Wood, as a part of the agreement, the law requires that this being a sex offense, that you would have to be a registered sex offender under Chapter 62 once you're released from prison for the rest of your life. You understand that?
Yes, sir.
And Mr. Manning, was a copy of Chapter 62 provided to Ms. Wood?
Judge, I provided her the admonishments under Chapter 62, and she did initial those. However, there was not a copy of Chapter 62 included in the paperwork, and I gave away my last copy at my last hearing. I do have an extra copy at the office that I'll bring to Miss Wood tomorrow, when I come to the jail to do my visits.
All right, thank you, Mr. Manning. All right, Ms. Wood, then let me ask you, at this time, how do you plead to aggravated sexual assault of a child?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection to stipulation as offered.
Stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Anything from the state?
Your Honor, just that a mandatory protective order was filed in this case and further, state sent out the victim impact statement about 60 days ago. We have not heard back. We have been unable to make contact with the victim, but we are in compliance.
All right. Thank you. Anything further from the defense, Mr. Manning?
Judge, I would just note, the first copy of the judgment that I got when I got to the jail, did not have credit time for Miss Wood. However, that has been corrected to show that she does have 133 days credit time, and that is corrected on the judgment that's with this paperwork.
Thank you, Mr. Manning. I appreciate that because mine didn't have it either. All right. Then the court's going to review the stipulation of evidence. All right, the court, having reviewed the evidence, finds sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement. The court hereby convicts Joyce Marie Wood of aggravated sexual assault of a child, a first-degree felony, assesses her punishment at 30 years confinement in the Texas Department of Criminal Justice. Court orders her to pay a $2,000 fine, $290 court cost, and $20 in reimbursement fees. Further, the court awards Ms. Wood jail time credit of 133 days for the time that she has already spent in jail on this cause. The court also finds that Ms. Wood, having been prosecuted and convicted under Chapter 62, that she is required to register as a sex offender for the remainder of her life when she is released from TDC. Ms. Wood, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted with the deputy.
Yes, sir.
Judge, I believe that concludes my business. Might be excused.
Yes, thank you, Mr. Manning.
Thank you, Judge.
Ms. Taberham, do we have anything else? I don't see anything else on the docket.
No, sir.
It's been a while since we don't have any fugitives, warrants, or anything like that. We don't have any extraditions or anything.
Extraditions? No, sir.
Okay, excellent. All right, then I appreciate everyone's work, and that will conclude this afternoon's docket.
Okay, see you in a few minutes.